I'm Marissa Allen. I'm a Senior Associate in the Private Client team at DMH Stallard.
I'm Sarah McGreer and I'm a partner in the Private Client team, and we are the people who would be assisting you if you decided to come and get some help with your probate.
I think one of the things that we want to talk about today is the probate process, as it's called, and what that actually looks like, what it means for executors, and also when you involve a solicitor in that process and those considerations.
So it's quite interesting because I think if you asked anyone who wasn't a probate solicitor what probate means, they'd think it means the whole process of administering someone's estate and getting their assets to the people they've been left to. But actually, of course, for us, we know that technically a grant of probate is one specific application where there is a will. And there are, in fact, a myriad of other applications that lead to this mysterious certificate. But if there isn't a will, then it's letters of administration. And you might have letters of administration with will annexed. So that means that there is a will, but there's something wrong with it. So the executors can't act, or perhaps the executors have died. So when we're talking to clients and they say probate, we might actually interpret that slightly differently to the whole process. But obviously, if we take probate to mean that process, then I think we usually break it down into 4 or 5 stages for clients.
Yeah, I think the first stage that we would look at is gathering the information and identifying the assets and liabilities of the estate. In that process, we also look at whether the grant of probate or grant of letters of administration is actually needed. And it really does depend on what the assets are, how those assets are held and where those assets are held. Different banks have different policies as to whether they'll release money with or without the grant. Equally, just because you have a property, it depends on how that's held and whether that passes automatically to a survivor or whether you do need that grant to deal with the property. So I think that's really, in our opinion, stage 1, identifying what's in the estate and whether you need that grant. And then you move on to step 2, which is dealing with HMRC or deciding whether you need to deal with HMRC.
So working out whether you've got any allowances or reliefs that you can apply to the estate, which mean that we don't have to go down that process. So just to explain, there are kind of 2 processes. There's one where you can go straight to the court application for the grant, and there's one where you first have to give HMRC a report of the inheritance tax position. Now, it might not mean that there is any inheritance tax to pay. Mm-hmm. There's just certain allowances that have to be claimed through the longer process. Mm-hmm. But in some cases, if there is tax to pay, then of course you have to make at least the first instalment, submit that to HMRC, and then wait 20 working days for them to give us a code, which then allows us to go forward to the actual court application, which is the actual probate and the eventual awarding of the certificate, which says that you or I or whoever is the person who's authorised by the court to deal with the estate of the deceased.
We've found that the Probate Registry are much quicker now at dealing with applications, but if something is wrong, if you haven't got that authorisation first from HMRC that there's no inheritance tax due or that it's been paid, that really delays the process. And as soon as your application is stopped with the Probate Registry, that's when you're in a difficult place and things take a lot longer. So it's really important to get that application right. And so hopefully it goes through as quick as possible.
Yeah, and of course we can look at a will or an application for letters of administration, and we can sometimes see the potential problems. So we might look at something and say, okay, this person's made a homemade codicil and it hasn't quite worked out. They haven't got it properly witnessed, or their signature's weak or something like that. And we know what the Probate Registry is likely to ask for. So we can send it with the initial application, hopefully smoothing the way before we move on to getting the certificate. And the next stage, which is then actually looking at what the assets are, and working out how you're going to distribute them and sell them or give them to different beneficiaries. And then all the things that flow from that, which I think a lot of people don't anticipate. It's the so-called rat's tail of it, the bit that can go on for a really long time.
Yeah, I think one of the things that we've seen is that people don't necessarily think that there's ever going to be a capital gains tax liability. Once you've paid inheritance tax, you think, okay, that's fine, there's no more tax to pay. But actually, if a house sells for more than the probate value, if shares sell for more than the probate value, you're triggering a gain, and that needs to be reported to HMRC and tax paid on that. We've seen the allowances decrease in recent years, so there's more likely to be a tax liability for capital gains tax.
And of course, corrections to the IHT account, there are certain things that you can claim back. So if you sell for less than the accepted probate value within a certain period, you can actually go back and say, okay, well, we reported it at this amount and it actually sold for less. You can claim some inheritance tax back.
Yeah.
So there's quite a lot of work to do, and that process can be a lot slower than the initial process of getting the code and getting the grants.
Yeah, we do, in terms of how long the period of administration is, it varies so much. As I said, it's a lot quicker to get the grant now, but actually that post-grant administration, the final stages can go on for quite some time. One of the things that we've also seen is the requirement to register an estate that's gone on for more than 2 years with the Trust Registration Service. And even if it doesn't look like there's a trust in the will, you just need that wording to be held on trust, and that has created a trust. And if that trust isn't wound up within those 2 years, the estate isn't administered within that time frame, you have to go through a whole different registration process with HMRC and then close it once it's done. So it's
often
just
moments later, just
Yeah.
met the requirement.
Exactly.
But there's also whether or not income tax becomes an issue. Again, a lot of people say, well, I've already paid inheritance tax and now I've got to pay capital gains tax and income tax. But there are certain circumstances where you have to make a formal return for income tax purposes, even if actually there isn't any income or very much income to report. And the penalties for not doing that are quite harsh and quite difficult. I didn't know is not an excuse. So we need to look at that. And then also there is an alternative informal procedure for reporting income tax, which you might be able to use. So it's sort of working out which one of those applies and hoping it's the informal one, because the formal one takes ages. But just that whole process, it can take a while before we move on to actually distributing to people and deciding how that's going to be done. And I suppose people say, what's the point in having a solicitor? I can do that. That looks easier. It's just adding up what they had and working out what the tax is, and then we can distribute it really quickly. It wouldn't take this long if I did it, sort of thing.
I think one of the things that we see is actually the period of time that you need to wait after a grant has been issued, where somebody can bring a claim against the estate as a dependent. And it's just being aware of those timeframes. As an executor, you have a responsibility and you can be held personally liable. And that's a real responsibility for an executor or a personal representative to make sure that they're aware of these timeframes, that they take adequate steps to protect themselves. And I think that's something that maybe people don't understand, particularly when they maybe don't have a personal relationship with the person that's died. They don't know all of the family circumstances.
It's also knowing what you don't know, isn't it? So I've had clients who've come to me and they've given me the information for the date of death. And then we sort of looked at, did they make any gifts in the 7 years before they died? And they sort of haven't thought about that, and they don't realise there's an obligation on them to investigate whether the person did, because that could really change the tax position. Also, on a more positive note, I've had people who've come to me and I've been able to point out an allowance or a relief that they wouldn't have known about and they wouldn't have claimed. And HMRC are very good at saying you've misclaimed something. They're not so good at saying, I noticed that there's an adult disabled child. Did you know you can have this relief? And so by taking advice, they can actually save tax as well as making sure they pay the appropriate amount. And appropriate can be either way, more or less. And it's knowing the things to look for and being able to guide them and give them support and hopefully protect them against potential personal liability. But also, I think sometimes people assume it's quite straightforward because something's going straight from husband to wife, but there may be opportunities by deeds of variation to change the tax position, either on that estate or to improve it for the future, that aren't necessarily on the face of the papers. That we've done probably 5 or 6, 7 times a year, and so we're alive to them and can point them out to people. So I would say that's one of the reasons is the comfort of knowing that somebody else has looked at it. I think you said before that when you're emotionally involved in something, it can be quite difficult to cope with it, and so having someone who's a step back from it to look at it for you can be helpful.
It's also a very time-consuming process, and we have a lot of clients that have full-time jobs, and they think, I can gather this information and I can do this myself. But actually, when you start the process, you realise you might need to contact somebody, and their opening hours are 9 to 5. You end up spending a lot of your time going through this process. It's quite stressful at an already difficult time for you. And just passing that on to a solicitor, you've got that peace of mind that everything's being dealt with. You're, like you said, you're claiming the right allowances, but also you can have that emotional detachment from it.
And also stopping there becoming a situation within a family, because I think it can be, you're taking too long to do this. When am I going to be able to get my inheritance? Because you're taking ages. And actually, if they have handed it over to a solicitor, they've got a bit of backup to say, actually, the reason it's taking this long is not because your brother, sister, aunt, or whatever's taking too long. It's because of the process. And it can stop family situations becoming inflamed and suspicions coming in, which sadly are all too common.
Yeah, it's just that independent professional advice that gives that peace of mind to an executor at a stressful time, and in a role where there is a lot of responsibility.